Well, hello everyone, and welcome to Uncivil Law, where as always we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's coverage, we turn our attention to a motion I've long expected, the motion for Kohberger to change venue. You will recall that Kohberger is accused of killing 4 fellow classmates at a house off campus in a stabbing attack, and has been arrested and charged with these violent crimes. Now, normally, a change of venue motion is really hard because what you typically will do is you just do more of what you would typically do in any other case. And what do you normally do in a typical case? Well, what you do is you send out a jury questionnaire to a group of jurors. The juror questionnaire has some questions on it. You get the answers back for those questions. You then bring in a group of people. That group of people is called the jury veneer. Then from there, you'd ask them some questions, usually in court. And from there, you select your jury, including your alternates. So normally what you would do is you just do more of everything I just said. You'd send out the jury questionnaire to more people. It would have more questions on it to more thoroughly vet them. You would have a bigger jury veneer. You would ask them more thorough questions once they got into court. You would just do more. That is the typical practice. And typically that's not a problem because even the highest profile cases are usually you have a town that's not a problem. No one's ever heard of it because, people have lives and no one's ever heard of it. Even really high profile cases, it's not typically that difficult to find a group of people who really genuinely have not heard of it, at least in the modern practices, because, well, there's so much going on that's really hard for anyone to pay attention to everything. Maybe in the older days when there was only 3 media sources, when your choice of watching TV was CBS, ABC, and NBC, and that exhausts your list until eventually Fox got created, right? So when you had these options and there was only the local newspaper and, basically your media sources are these choices and not much more, having a polluted jury pool would be a lot easier because, well, there's not as much information and everyone's watching the same content. But these days, well, there's a lot more information, so it's really hard to pay attention to any of it. So normally you just do more, and it's not typically hard to find a jury that you can get. Now, in this particular case, I think that that's going to be not the case because this case happened in Moscow, Idaho, and no one lives in Moscow, Idaho. And everyone who does live in Moscow, Idaho is a college student at the college related to the murders. So finding an unbiased jury pool is going to be basically borderline impossible, it seems to me, in this particular situation because, well, there's just no one there. And everyone there has heard of it because it's a college town. And so kind of have passed the water cooler, so it's going to be really, really difficult. One would imagine to find an unbiased jury. So while typically a motion to change venue is not something I would have a lot of hope for, in this particular case, I would think that this is likely to be a very good motion because, well, Moscow, Idaho has no one in it and everyone who's there is a college student and people have heard about it. So there's that problem. So the defense is unsurprisingly moved to change venue, and I would be expecting this to be granted, absent some other consideration. And we'll go through this in the motion for the rules that apply to this thing and see what they have to say about the issues. So we'll go again and get started. We, of course, are in state court relating to the murders. The district court of the 2nd Judicial District of the state of Idaho, in and for the county of Lataya. This is the state of Idaho versus Brian Kohberger, and we have the memorandum in support of the motion to change venue. We'd really prefer to be tried somewhere else. Yeah. All right, comes now Brian Kohberger, by and through his attorney, hereby submits this motion. This motion is based on the 5th, 6th, 8th, and 14th Amendments and related amendments, and of course, Idaho relevant state law. This memorandum is supported by exhibits, which we may breeze through, but probably not go into much detail about, and with witnesses that might be called at the hearing if necessary. Mr. Kohberger, of course, is protected by the Constitution of the United States and the state of Idaho. His protection is to a fair and impartial jury, which we infringed without a change of venue. In this case, probably he would be. A fair and impartial jury cannot be found in Idaho County because of the offensive publicity, and more importantly, because no one lives there. The inflammatory nature of the publicity has included inaccurate information and immiscible information. The publicity has been extremely pervasive in the small community. Ding, 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 ding. That's the winner argument. Remedies such as enlarging the jury pool will not cure the problem because that's normally what we do, but we can't enlarge the jury pool because no one lives there. We can't enlarge it because there's no one to enlarge it to. So yeah, great. A brief discussion of the facts thus far. Media coverage of the case that later became State versus Kohberger began early in November of 2022 when news broke about the 4 homicides. Extensive media coverage has ensued for the 6 weeks in which the police investigation began prior to the arrest. There was quite a lot of news coverage about it in the arrest up to Kohberger. Quite a lot of publicity about it. Daily updates were available from the Moscow Police Department. Often participating in the updates or press releases was the Lataya County Prosecutor and Chief of Police. These broadcasts were played on television stations as well as print and digital media. Social media covered the investigation, with the Moscow Police updating its Facebook page and providing press releases and media statements written normally. Lataya County, I'll try to remember that. The Moscow Police Department included law enforcement partners from Idaho State Police and the FBI. Media coverage, including the market relating to Lataya County, was replete with stories after stories in local newspaper and news stations. Media focus did not stop with a locally targeted news station or newspapers. Not that it really matters, incidentally, because the relevant question is the jury pool. So even if it had stopped locally, I'm not sure it would really matter one way or another, but for whatever it does matter, it extended into magazines, books, crime TV shows, and current mediums of information and opinion sharing, like the internet. Immediately and consistently, the internet was abuzz with podcasts, tweets, Facebook groups, Reddit, YouTube, and TikTok postings. Once the police arrested Kohberger, the police was ready to, and has proceeded to vilify him without regard to constitutional guarantee of the presumption of innocence and a right to impartial jury. The media focus on Kohberger has been relentless and inflammatory. Pretty much, yes. All right, so we'll skip, all right. The great value of the trial by jury can certainly consist in fairness and impartiality. Those who most prize the institution prize it because it furnishes a tribunal, which may be expected to be uninfluenced by undue bias of the mind. I have always conceived and still conceive of an impartial jury as required by the common law and secured by the Constitution. Must be composed of men who will fairly hear the testimony which may be offered to them and bring in a verdict according to that testimony and according to law. This is not to be expected. Certainly the law does not expect it, where jurors, before they hear the testimony, have deliberately formed and delivered an opinion. The person who they are tried is guilty or innocent, according to Chief Justice Marshall, writing in the case of United States versus Burr. And then they have one hell of a citation, F.Cass. I don't know what F.Cass is. That's an interesting citation. All right, never mind. Pressing on. The early U.S. Supreme Court cases are often reported by the name of the reporter rather than U.S. So you'll often see where it has it like the name of the reporter in early constitutional cases. But I'm not familiar with F.Cass. So that's a new citation I haven't seen or I don't remember. So interesting. The U.S. Constitution, through the 6th and 14th Amendments, and the Constitution of the state of Idaho guarantees the accused a fair trial and impartial jury. You better believe it. The constitutional mandate of the fair trial by impartial jury requires a change of venue when an impartial jury cannot be impounded in the district in which the indictment is returned. Due process requires the accused receive a trial by an impartial jury free from outside influence, citing Shepard, which is a very famous case dealing with pretrial publicity. It is the case that has been rumored to be the basis of the TV show and movie The Fugitive, although the producers of it deny that it was the basis of it. But in Shepard, there was a doctor accused of killing his wife and got way, way too much publicity, including my particular favorite detail. The members of the press decided to take photographs of the jury and jurors while the case was ongoing and published their photographs, the photographs of the jury. Published their photographs with their names, jobs, and their locations in the paper. And the Supreme Court thought that this might be a problem because, basically the sentiment at the time was this guy should hang. And they thought, maybe publishing the name, photograph, and locations of the jurors might be a bit of a problem as it relates to getting a fair jury. That was Shepard. Yeah, it went a little bit off the rails. So yeah, that happened. Okay. So maybe we shouldn't do that. Where there's a reasonable likelihood that prejudice in a community will prevent the fair trial, change of venue should be granted. Consequently, the question posed in the motion by change of venue is whether there's a reasonable likelihood exists that pretrial publicity has affected the impartiality of prospective jurors. The phrase reasonable likelihood denotes a lesser standard of proof than more probable than not. Fair enough. The determination of whether to grant the trial for change of venue is addressed to the discretion of the trial court. Sure is. In exercising this discretion, the trial court must keep in mind that although the mere presence of pretrial publicity is not enough to warrant the change of venue, a defendant's inability to make a detailed and conclusive showing of prejudice is not proper ground. In other words, pretrial publicity is not the issue because, of course, First Amendment. And this has been a thing as long as you care to believe. And incidentally, also is arguably more of a problem, generally speaking, in the past than now. As I sort of alluded to in my earlier discussion, this was more of a problem when there were fewer media sources. And depending on how you judge the relative weight of such things, you can make a fairly credible argument that this was even a bigger problem now, this is even a bigger problem in antiquity than it is now. Because while now there's mass media, in the day, there was nothing happening. And so the town crier didn't really have much to cry about except, what was going on in the trial. And so the pre-trial publicity, particularly in the community where the trial was occurring, was, if anything, potentially more vociferous at particular examples in the past, including in Europe, incidentally, before the American founding, where, depending on how you judge such things, the hubbub and the publicity and the public quasi-lynchings that were happening basically outside the courthouse were of a spectacle and degree that even modern times has nothing on. So while modern times has increased the breadth of communication, in the older times, well, there wasn't much to talk about. Also, people couldn't read. And so since they couldn't read, they talked about what there was to talk about, which was often the trial. And often they went to watch it because, well, it was the form of entertainment of the day in many situations. So yeah, this is not necessarily a new problem. So we are well familiar with people talking about the case. This is not necessarily the problem, but we are concerned about the balance, right? We're concerned about the balance between people's right to talk about the public trial in a public way and also the defendant getting a fair trial. So we have to balance these considerations as far as it goes. Great, fine, we all understand this problem. Prejudice seldom can be established or disproved with certainty. That would be hard. A showing of actual prejudice is not required. Because how would you do that in advance? That's not even hypothetically possible. Because how would you know that people are actually prejudiced in advance? You can't really know that. I mean, you could guess that people would be prejudiced based on a whole bunch of things, but you don't know for sure what they're going to do, right? Maybe they'll be unprejudiced. And we would always hope, but we're human beings, so our confidence is somewhat reduced in some situations. Any doubt as to necessity of removal should be resolved in favor of a change of venue. That being said, this is a somewhat disfavored motion, particularly in the modern practice, but, if anywhere, probably here. Prejudice may be properly be presumed when either inflammatory publicity about the case has so saturated the community, it's almost impossible to draw an impartial jury from that community, or so many jurors admit to disqualifying prejudice, the trial court may legitimately doubt the avowals of impartiality made by the remaining jurors. So basically, yeah, that's the thing, right? That's what we're looking for. Has the amount of publicity within the community, because that's what we're really concerned about. We're concerned about getting the jury from the district where it's going to be concerned. If somehow this jury is an insulated island, I mean, this hypothetical seems completely ridiculous, but let's just play games, right? Because we can play games on our mind. If somehow this case has gotten publicity everywhere except this particular jurisdiction, then we don't have a problem, because why do we care? All right. If this case has got interest literally everywhere and everyone knows about it, except in this community, no one knows about it because I don't know reasons. This is a strange hypothetical, but let's play games, right? Then we don't care. And exactly the opposite way around too. If literally everyone in the community has heard about it, but no one externally has heard about it, we care a shit ton, because what we're concerned about is the jury from this jurisdiction. So what we're concerned about ultimately is the amount of pollution there is in the relevant community. And if we have more community, if we have more people, if we have a broader population, then we're less concerned. Because, well, it's not the olden days and people have other things to talk about other than the one trial going on with the crier yelling in the town square. There are many things constantly going for their attention. So, we're not concerned about publicity. We're not concerned about people talking because normally we just do more. We're concerned with it becoming so saturated and so problematic that basically we need to give up hope and try something else. And, again, this kind of situation seems like the possibility for it. Okay. Publicity by itself does not require a change of venue, because if it did, we'd have to change every case, and that would be dumb. However, a presumption of prejudice requiring a change of venue attend only the extreme case. Again, we don't normally worry about this because First Amendment is a thing too. The test for the extreme case remains whether the trial atmosphere has been utterly corrupted. You're getting the idea, right? You're getting the idea that this has to be so saturated that there's basically no point in trying. Mr. Kohberger is not on the eve of trial, thus no actual jurors would be called in at this time. Instead, extensive surveys, not that we really need them in this particular case, show actual prejudice in how State versus Kohberger is an extreme case to which venue change is required. Yeah, I mean, again, I'm not sure that strictly speaking you necessarily need surveys, because you can just use a little common sense. Again, this is a college town. No one lives there except the students, basically. It's like, yeah, the students have heard of it. The people have heard of it. It's kind of a big deal within the relevant community, but sure, we can do some surveys to prove the obvious, but yeah, we got it. Yeah. It is not possible to impanel an impartial jury in Latoya County, however we're pronouncing this today, based on the pervasive and inflammatory press coverage. I think that sounds about right. Brian Christopher Kohberger, once arrested, quickly became a recognized name. That's true. The investigation into the death of the 4 college students has captured the attention of the community, the state, the country, even beyond the United States, long before the arrest of Kohberger. Also, facts. Since his arrest, interest in the charges, who he is, and backgrounds continues rather than fades. Also, facts. The continuous nature of the coverage, often inaccurate and misleading. Fair. The impact of the media coverage and the small size of the community, that would be the biggest problem here, make the case against Kohberger extreme. I agree. Latoya County. Media saturation in Latoya County has been continuous since the deaths were reported. Preach. Public interest does not wane. Stories about the case and Kohberger come in the force of published books, television, crime shows, internet platforms, social media, news stations, and newspapers across the country. The most coverage from these sources has occurred in Latoya County. Coverage runs the gamut on items contained in court filings to report on what unnamed sources have said, as well as reporting based on what other media stories. These stories are often rife with misinformation and speculation. That will happen. The amount of media stories, inaccuracy, and speculative nature of the stories, and impact of potential jurors show State versus Kohberger is extreme. The impact of the vast media coverage on the potential Latoya jury demonstrates the nature of the change. Latawa. Latah. Media from locations outside Latah County is easily accessible to a potential juror. However, Latah County residents have received the most media saturation within the state. TrueScope is a media collection company, and based on analysis completed by the company, media coverage directed in Latah County makes up 36.1% of coverage in the entire state. The statistics indicate 36% of traceable media. That means newspapers and television. More than a third of the total print and news coverage is centered in Latah County. More than 1/3 of traceable media in the county is astounding. However, considering Latah comprises only 3% of the entire population, it's oversaturated. Yeah, that's a bit of a problem, right? Okay, so the entire county is only 3% of the population, but it's 36% of all the media. So somewhat disproportional. Yeah, I agree. The prolific media coverage in Latah County is not a mere passing story. The content is not benign. Rather, it's inflammatory, emotion-evoking, and often misleading, false, and poorly sourced. There's no reason to believe media coverage will slow, regardless of how long the case takes. There will be no elapsed time between media coverage and the jury trial. Preach. In Exhibit C, TrueScope depicts a visual of peaks and valleys in coverage rather than continual decline. The valleys, followed by spikes, correlate with hearings. Based on the pattern, it's not reasonable to believe a decline will proceed prior to trial. Yep, I don't think so too, either. I don't think that's going on. Latah rhymes with Utah. I'll try to keep it in mind. Media coverage, while extensive, must also be prejudicial, which just means that it harms one side or the other. The prejudicial effect of Latah County is shown in the survey work performed and analyzed by Trial Innovations. The survey consists of questions relating to the case, recognition in general, specific information recollection, and impact for prejudgment. This type of tool is widely accepted. Analysis of community attitude surveys conducted by Trial Innovations demonstrates that Latah County citizens who are over the age of 18 and biased and have knowledge of the information that's inflammatory, misleading, and or false. Community attitude surveys shows case recognition is 98%. I would think. And who the 2% is, who can say, right? 2% of the population haven't heard of it? I don't know about that. 70% of those recognized the case have already formed an opinion, the opinion being guilty. The survey shows that those that have the opinion of guilt, 51% state they have a fixed opinion, meaning there's nothing that will change their opinion. This is demonstrative of the prejudice in a different case, as the survey results show both presumed prejudice and actual presence in Latah County. I'm just going to do my best on the name. I can't. I can't. Latah, I'll do my best. The threshold in Idaho is reasonable likelihood, as the court has stated. It's sufficient for the accused to show there was reasonable likelihood prejudicial news coverage presented fair violation of the Sixth Amendment to the United States Constitution. In order to distinguish the media impact of Latah County residents, companion surveys were conducted in 3 other counties. The comparative surveys, while showing high case recognition and similar prejudgment cases, have important differences of lower recognition of media items. The inaccurate media items have a high link in potential prejudgment case of guilt. Additionally, comparative surveys show a low number of people following the case and fewer personal connections, which makes sense because, again, Latah County is a college town, and there are going to be more personal connections with people involved in the case. The United States Supreme Court also distinguished between jurors' mere familiarity with defendants and actual predisposition, which, fair enough. Dr. Ellman's work shows actual predisposition in Latah County. One of the primary considerations in determining pretrial publicity and corruption of a community for venue is the size and characteristics of the community. Yep, that's kind of where it boils down. Right? That's kind of what it boils down to in the modern jurisprudence. How big is the community? That's sort of where it boils down. Which, depending on how we're considering such things, could be the city, the county, it could be portions of it. So, but how big is the relevant community? Can we find a fair jury? Can we find someone that doesn't have bias? So the size of the community is going to be a major drawing factor in the modern jurisprudence. The population of Moscow is only 41,000. Yep. And of that, 19% are under the age of 18, making them ineligible to be a juror. 19% are over the age of 65, all but approximately 2,000 of whom may be requested to be excused on the basis of age. The census statistics reduced the eligible population on age alone by 38% to 25,000 before any juror for qualifications are asked. Ada County, 12 times larger than Latah County, provides a greater hope of seeking an impartial jury. I would think. The small size of Latah County is further challenged by connections to the case that do not exist in other counties because, the college isn't there. Some of the major employers of the community are people connected to law enforcement and the University of Idaho. The university is the single largest employer in the community with 4,500 employees. That's a lot of people, particularly out of the 25,000 people that are there. The city and county who employ law enforcement have more than 300 employees. The controlling precedent in this case is Patton and Shepard. Upon a showing of abundance evidence of the record demonstrating media saturation in a small county with facts about the case, false information about the case, and otherwise inadmissible material, a change of venue is appropriate. In Shepard, the Supreme Court held due process requires a change of venue or continuance when the defendant can show a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial. More specifically, because a criminal defendant has a right to an impartial jury, a court must grant a motion to change venue if prejudicial pretrial publicity makes it impossible to seat an impartial jury. The United States Supreme Court distinguishes between publicity that's largely factual and that's which is insidious or inflammatory. Again, this language is all pointing to the same idea, which makes sense, right? We're trying to describe the same thing. What we're concerned about is the community at large being overly tainted and overly prejudicial and overly biased one way or another based on things that make it difficult for either side, incidentally, because we're concerned about a fair trial for all concerned. So, yeah, a bit of an issue. Fair enough. The name Latah comes from words that translate the place of pine trees and stones. Noted. Of importance is the small community impact on a juror. Jurors sitting in Latah County will have no anonymity. Preach. And trial where that caused by a surveyor released in reports to the prosecution and police, there's no doubt that everyone who knows the seat jurors are in this trial is not moved. Jurors will be under immeasurable pressure to reach a guilty verdict and then death. The affidavit of Skate Sunby is in support of the motion states, two distinct disadvantages or two distinct dangers arise from holding the capital trial in a small community where the victims are local residents. The first is that jurors will be distinctly aware of community outrage, and as a result, some are likely to fear that many of their neighbors and coworkers will ostracize them if they do not return a sentence for death. Fair enough. Mr. Sunby asserts that based on over a decade of research and hundreds of interviews of death-qualified jurors, the pressure of deliberations in a capital case in a small community are different and carry unique pressure. Not really, but you understand the deal, right? Because the smaller the community, the more their pressure, because the more desire to conform, you get the idea. The lasting impact of extensive media coverage cannot be undone through voir dire, which is normally, again, what we do. Normally, how do we solve this problem? We just do more. More juror questionnaires to more people, asking more questions. We bring more of them in for a larger veneer. We ask more questions. We spend more time. Everything is just more. So normally the way we'd solve this problem is just more. More of everything. Can we do that in this case? Not really, no. There's enough evidence to presume prejudice incapable of remedy in Latah. As the Supreme Court said in 1908, bias or prejudice is such an elusive condition of the mind that it's the most difficult, if not impossible, to always recognize its existence. It might exist in the mind of one on account of his relation to one of the parties who was quite positive that he had no bias and said he was perfectly able to decide the question, wholly influenced by anything but the evidence. Yep, fair enough. The influence that lurks in an opinion once formed is so persistent that it unconsciously fights detachment from the mental process of the average man. And psychology impact requiring such a declaration before one's fellows is often farther. Where so many times admitted prejudice, such a statement of impartiality can be given little weight. Certainly the statements of Latah County will mean well upon a promise to set aside information gleaned via media and conversation with others. However, this is often unknown mindset that new information filters through. Further unknown bias exists that cannot be corrected for. Fine. In Delaney versus United States, this court recognized the difficulty of assuming the average juror may confidently exclude even unconscious influence of his perceptions as to probable guilt engendered by a pervasive pretrial publicity. Claims of impartiality should be rejected where prejudice is widespread. In U.S. versus Angelo, the court stated where a high percentage of the veneer, again, that word for the big jury pool that we start with, the jury veneer, very fancy word, right? So all the jurors we haul into court, that's the veneer, very, very fancy. Where a high percentage of the veneer admits to a disqualifying prejudice, a court may properly question the remaining jurors' avowals of impartiality and choose to presume prejudice. So if enough people say they're biased, we're not going to believe the rest. Fair enough. In a community where most veneer men will admit to disqualifying prejudice, the reliability of other prostations may be drawn into question. For it is more probable than not they are part of a community deeply hostile to the accused, and more likely they may be unwillingly have been influenced by it. You do swim in the water of your community. Social science research confirms the inadequacy of voir dire. As a remedy in such case, Dr. Ali states the impact of media coverage causes a potential juror to have a preset opinion about Kohberger that provides a backdrop for new information that likely will be interpreted to conform to already formed beliefs. Pretty much. A good example, okay. Additionally, this impact is increased because much of the initial information came from authority figures. The early information was accompanied by emotions, which deepened the preset opinions. A good example specific to the population of Utah comes from the University of Idaho's president. He published a book with a chapter called When Evil Visits Your Campus. I mean, that does suggest maybe he has some thoughts on the issue. He dedicated the book to victims and claimed the proceeds from the book are being used to create a memorial garden. In his book, the president of Idaho, University of Idaho, tells of the great fear that existed on campus and in Moscow. He writes about self-defense classes and counseling that goes on to this day. He expresses how the community came together, bringing several thousand residents to a candlelight vigil. He explained how his close work with law enforcement during the months after the crime helped him make decisions. He shares in writing his theory about Kohberger's guilt. The impact of the message from a community leader in a highly emotional atmosphere creates a level of strong potential for bias in non-existent in other communities. Yes, I think you are more likely to find someone else somewhere else. The Idaho rules provide direction to the court to change venue upon finding an impartial jury cannot be held in the county where the indictment was found. The foregoing argument related to constitutional protections apply with regards to Idaho criminal rules. Without repeating those arguments, we turn to the appropriateness of the venue change pursuant to the rule, authorizing the court to change venue for other reasons. The Idaho rules allow the court to transfer proceedings to another county for the convenience of the party and witnesses and in the interest of justice. The court should consider, along with the foregoing, these additional factors that are available to the change of venue to Ada County. Ada County is the largest county in Idaho, with more than 10 times as many potential jurors than Utah County. Given the familiarity with this case throughout the entire state of Idaho, selecting an impartial jury will be challenged. The best chance is to have the largest pool, which makes sense, right? That makes sense. The larger the pool of people, the better probability that we can find people who haven't heard about it or have been biased about it, where it hasn't been the talk every waking moment of the day, and people might only have passing familiarity with it. So yes, that sounds like a logical thing to do. So I think the judge should probably grant this motion. I think we'd have a lot more luck in Ada County. Yeah. The Ada County Courthouse can accommodate the trial. There are large courtrooms with adequate space and tables for the attorneys in Kohberger. The large courtroom provides space for each counsel to keep materials and necessary conversation out of eyeshot or earshot of another party, spectators, or media. Due to the size, the courtroom can accommodate a large number of spectators, and there's overflow space available for the public to watch the trial. Ada County has adequate security for the safety of the parties, court staff, and jurors. There are multiple jury rooms and many private restrooms away from the public to accommodate such a large jury. The courthouse and security are set up to assist jurors to and from the courthouse without media exposure. Any consideration relating to the costs of prosecution and defense make Ada County a logical choice, with the largest airport in the state. There will be a number of witnesses traveling into Idaho, and Ada County is a more cost-effective option. The Moscow-Pullman Airport has few direct flights, especially in summer months. This will require most witnesses to travel from Spokane, Washington, and rent a car to drive to Utah County Courthouse. Another consideration for the court pursuant to law is that the chief of police is running for sheriff. Chief Fry is a witness to the case. He is engaged in extensive media statements. If elected, his position statutorily gives him the power to summon jurors if directed, and to be in charge of the impaneled jury. That's a little bit problematic. If elected, a conflict is created in his statutory duty to be in charge of the impaneled jury when he's a witness in the case. This is one of the interest of justice factors that supports the venue change of Utah County. Yep. Thus, the conclusion. Short, sweet, and to the point. I appreciate that. I appreciate it as a lawyer, and I appreciate it as a hypothetical judge. Please do not write more words than you need. 13 pages with plenty of words. It's all the words I need. It's fantastic. Thank you. This is no ordinary case. Kohberger has been accused of killing 4 individuals. The state seeks the death penalty if trial should result in conviction. As such, Kohberger's constitutional rights may be carefully guarded. And as has been stated before, although the defense didn't mention it for some reason, death is different. I'm surprised they didn't cite that too, to be quite honest, because death is different. So anytime you have death penalty, anything, everything gets elevated and kicked up to 11. Because, well, death is different, as the Supreme Court itself has noted on more than one occasion. Yeah. Rarely does even a small community come together, and both number and quality of unity has happened here. Latah County is in all regards a nice, quaint, close-knit community that sticks together. While a small, close-knit community is what is hoped for in a small town, constitutional rights must be carefully protected. Mr. Kohberger has the right to presumption of innocence. He's guaranteed the protection of a fair jury and a due process. Given the level of bias in Latah County, Kohberger cannot receive a fair trial. An impartiality of jury cannot be picked. The court must protect the constitutional rights and grant the chain of venue. Signed, the defense. To which I agree. And then, of course, the foregoing is signed, and all the rest of it. And then there's some press releases. This is just exhibits. So some press releases from the past, just showing, the attention that the thing has gotten, showing all the press releases. Here we have a press release from the coroner. Some more Moscow updates. You get the gist, right? So this is just a list of various statements to the press by various officials. Lots of stuff there. News reports. You get the gist. So just showing the thing. So great. So I think this motion should be granted. I think it's a gimme motion. I think it's a fairly gimme motion. And I think not granting it would lead to reversible error, because I just don't see how you can possibly find a relevant jury. And if you have to wind up transferring this thing for venue after you start jury selection, you just waste so much time. All right? So the court could defer judgment and see how jury selection actually pans out. But why? Because if you have to start over again, you waste a lot of time. So I think that there's cause to move this, and I think it should be granted. It's typically hard to do, but I think it's proper here. So that's all I have to say about that. Let me see if there were any questions before we wrap up the stream. Only Kissy, who gifted 20 gift memberships. Thank you very much for that donation. And I'll take just a second or two to answer any questions, but I think it pretty much covers and speaks for itself. So much time has already passed. In some ways that's true, in some ways not. We're not really close to having a jury, and this is timely. So a lot of preliminary stuff is done. There's no reason any of that preliminary stuff has to be redone, because they didn't ask for it until now. So the next judge would probably take everything that's happened as given and be loath to set it aside. Because why? So you would probably take everything as given, everything transfers over, and you just start with a new judge and you pick it up with everything that's happened being basically happened, and all the rest of it. You just bought a Franken-Truck hoodie. I'm glad you like it. Judge said he got a large number of requests for excused absences from jury duty back when the trial was still scheduled, before BK waived his right to a speedy trial. Yeah, that too. People don't want to serve on the jury. That's a factor too. Is there any jurisdiction that the case isn't totally aware of in a potential jury pool? Yes, I think so. And we discussed that, right? We discussed that. At least in our modern, the issue isn't necessarily finding people who are unaware. Although I think even that you could probably find some people who are. But the issue is finding people where it hasn't necessarily saturated their lives. And if you move this over at Ada County, where there's 400,000 people who live there, yeah, I think you're going to find people where the balance is much more probable. And that's basically going to be as good as it gets, probably. So yeah, I think you can do this. And you still have to do more, right? It just wouldn't be futile. It wouldn't be futile like it would be in Moscow. So you'd still do you'd send out more questionnaires to more jurors that are more thorough and bring in more people for a veneer and ask them more questions. So you still do all the more. It just isn't futile, because you have a larger pool to pick from. And so it doesn't, you can do it. I think. Yeah, I think. I think it won't be, I don't think it will be really, I don't think it will be terribly impossible to find jurors who have heard of it, but you might even find some jurors who haven't heard of it, but that'll be harder. But you probably won't be hard to find a group of jurors that have heard of it, but they've, hasn't just been something that's been part of their everyday life. Someone who saw a headline every once in a while, but, doesn't really know much more than that, maybe. So I think you can find jurors who are relatively naive and uninformed about this particular case, because there's so many things for them to be informed about, plus they have to live their own daily life. It doesn't necessarily require them to be bad people or bad jurors. There's just so much to focus on. You can't keep everything in your head. So yeah. I look great in black. Thank you. I went to the gym. This is what I wore at the gym today. I did my workout. I posted it. It was okay. It was a good workout. I went twice last week and like twice the week before, and only once the week before that. So I've definitely been off my workout game, but I keep trying to get back into it. And every day we can pick ourselves up and try again is a day worth of mentioning. So, hey, could be worse, right? Also, I made the room a little darker, as you can see, to make the light a little bit more consistent. So, try to make things a little bit nicer for you perpetually. Always thinking. Always thinking. The grits didn't turn out super great, unfortunately. I added way too much white wine, and it really overpowered the other flavors. So that was disappointing. So I wound up having to drain all the liquid out of it and add water that just I added flavor to and remix it together and cook that back for a little while. So I was able to salvage it, but I added way, way too much white wine when I cooked it originally. So that was a problem. But I fixed it mostly. So, hey, it worked out okay. You lifted 10,000 pounds. I think I did 11,000 pounds or 12,000 pounds today. So yeah, we did okay today. There's no such thing as too much white wine. There was in this dish. It was overpowering the flavor. It was way too much in this dish. Yeah, it was too much in this dish. I should have added no more than like a cup. Probably like, yeah, I should have added no more than a cup. I basically added like half a bottle. It's just way too much wine. Oh well. What else can I answer for you? All right, well, I'm going to go ahead and sign off for now. I hope you've enjoyed the stream. I've certainly enjoyed the stream, and thank you very much to the fine person in Discord who recommended it to me. I do really appreciate that it was suggested to me by Starvin Pig, I believe it was, who provided it to me, and I appreciate them suggestion. If you'd like to see your story covered, make sure to drop by on the Discord, and maybe your story will be covered if you provide a suggestion. So, hey, we had one person provide a suggestion today, and that's how we did the story, and maybe your suggestion will be covered next time. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.